The Voting Rights Act of 1965 made the 15th Amendment at long last a truly effective part of the Constitution. Unlike its predecessors, this act applied to all elections held anywhere in the country, state and local, as well as federal. The 1965 law directed the Attorney General to challenge the constitutionality of the remaining state poll tax laws in the federal courts. That provision led directly to Harper v. Virginia Board of Elections in 1966. The law also suspended the use of any literacy test or similar device in any state or county where less than half of the electorate had been registered or had voted in the 1964 presidential election. The law authorized the Attorney General to appoint voting examiners to serve in any of these states or counties. It also gave these federal officers the power to register voters and otherwise oversee the conduct of elections in those areas. The Voting Rights Act of 1965 created a further restriction on those states where a majority of the electorate had not voted in 1964. The act declared that no new election laws and no new changes in existing election laws could go into effect in any of those states unless first approved or given pre-clearance by the Department of Justice. Only those new or revised laws that do not dilute or weaken the voting rights of minority groups can or could survive the pre-clearance process. The pre-clearance hurdle had produced a large number of court cases since the passage of the law. Those cases showed that the laws most likely ran afoul of the pre-clearance requirement and are those that made these kinds of changes. 1. The location of polling places. 2. The boundaries of election districts. 3. Deadlines in the election process. 4. From ward or district election to at-large elections. 5. The qualification candidates must meet in order to run for office. So you couldn't change those, or if you tried to change those away from being from the minorities or just to discriminate, you wouldn't make it through this actual clearance process. Any state or county subject to the voter examiner and pre-clearance provisions can be removed from the law's coverage through the bailout process. That relief can come if the state can show the United States District Court in the District of Columbia that it has not applied any voting procedures in the discriminatory way for at least 10 years. So there were ways to get out of having to go through the pre-clearance process, but you had to show that you were making changes towards the better. The voter examiner and pre-clearance provisions of the 1965 Voting Rights Act originally applied to 6 entire states: Alabama, Georgia, Louisiana, Mississippi, South Carolina, and Virginia. The act also applied to 40 North Carolina counties. The Supreme Court upheld the Voting Rights Act in 1966, and this was in South Carolina versus Katzenbach. It upheld that Congress had the right to banish racial discrimination laws in voting. So it is upholding the Voting Rights Act of 1965 to make sure that nothing discriminatory is being put into place. So here are some of the changes that happened throughout the years. The 1970 amendment extended the law for another 5 years. The 1968 elections were added to the law's triggering formula. The result that added more counties in 6 more states. Alaska, Arizona, California, Idaho, New Mexico, and Oregon were added to those laws' coverage. So they were trying to stop the discrimination, and now they've realized it's spreading throughout the country, or was all over the country. The 1970 law also provided that for 5 years no state could use literacy as the basis for any voting requirements. That temporary ban was, as well as resident provisions outlined in the law upheld by the Supreme Court in Oregon versus Mitchell. So you didn't have to show residency in order to be able to vote. They couldn't post any residency requirements on you, and that was being upheld in a Supreme Court law. In 1975, the law was extended again, this time for 7 years, and the first 5-year ban on literacy test was made permanent. Since 1975, no state has been able to apply any sort of literacy qualifications to any aspect of the election process. The law's voter examiner and pre-clearance provisions were also brought in 1975. Since then, they've also covered any state or county where more than 5% of the voting age population belongs to certain language minorities. These groups are defined to include all of the persons of Spanish heritage, Native Americans, Asian Americans, and Alaskan natives. This addition expanded the law's coverage to all of Alaska and Texas and to several counties and 24 other states as well. In those areas, all ballots and other official election materials must be printed both in English and in the language of the minority or minorities involved. 1982 amendments extended the basic features of the Act for another 25 years. In 1992, the law's language minority provisions were revised, and now they apply to any community that has a minority language population of 10,000 people or more. In 2006, Congress unanimously passed the Voting Rights Act again for another 25 years. So we can look forward to that being voted on in 2031 to extend it again and to make any changes that need to be made to make sure that there is nothing discriminatory happening throughout the United States. Okay, go back to class jump. Tell me one way voting rights changed over time since 1965, or answer the question, do you think there need to be other amendments added to the Voting Rights Act of 1965 to ensure that all persons are not denied the right to vote?